Back to mention item number 15. My lord, on the last occasion, I was granted time to file additional affidavit. I need some more time, my lord. Can it be on 23rd of February, my lord?
Which item?
Item 15. 1-5.
No, you're supposed to file additional
Yes,
affidavit.
I need some more time. I need to get some documents from the registry.
I am for the respondent, FCI respondent.
Can it be on 23rd of February, my lord? My lord, friend comes from outside.
23rd of February.
23rd of February.
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 Heard Mr. Deepan, the learned counsel for the petition. Also heard Mr. BK Singh.
BK Singh.
BK Singh, you're standing
Of FCI.
FCI.
FCI. Learned counsel FCI. Government advocate is also here.
Yes.
Also 1, 2, 3, 4, and 5.
Also heard government advocate. Your miss? P. Pang, the learned counsel, learned government counsel, government advocate appearing on behalf of 1, 2, 3, 4, and 5. 1, 2, 3, 4, and 5. It is submitted by Mr. Pang that inadvertently, then he was supposed to file the additional affidavit today, but inadvertently could not be filed today and need some more time for filing the same. There allowed, let the matter be listed on 23rd of February.
And back to mention item number 19 also, madam. I am here for a response. Can it be after a week, madam?
In item number
19, madam.
19.
19, madam.
It was a matter of 2018.
Yes, I have some personal difficulty next week, madam.
The request of so and so, let the matter be listed after 1 week.
Problem.
I beg to mention item number.
Fixed by the registry.
My lord, I beg to mention item number 21, 22, my lord. My lord, as agreed by the my lord, all the parties, my lord, can this matter be listed on 15th March, my lord?
Parties, what have you said?
All the parties, with the consent of the parties, my lord, other parties.
Other side.
Yes, I'm appealing for the petitioner also in this case.
No, you are for the petition. And you are appealing for?
For respondent, my lord.
The request made by the learned counsel for the respondent with the consent of the other side. The matter is adjourned today. Let the matter be accordingly listed on. You want any date on 15th of March? 15th of March. 15th.
Obligations.
Your Lordship, I beg to mention item number 3.
3.
Yes.
Yes.
Your Lordship, day before yesterday only, I have received the reply copy of the respondent. And
You are for the petitioner.
I'm for the petitioner, yes. And there are so many new facts inserted in the reply. So I have to take some instruction from my client. And right now my client is out of station. She is at Bangalore due to some urgent work. So this matter may be listed after 3 or 4 weeks.
You are Miss?
M. Yaram.
For
My lord.
Sunil.
My lord, I'm on behalf of the respondent, my lord. So we are praying that the matter may be fixed on 15th of February, my lord.
No, Your Lordship. Actually, right now I don't know when my client will come back, return back from the Bangalore.
My lord, its urgency is there, my lord. There in this matter.
Your Lordship, I'm going to file a reply.
My lord, they can
India
take the adjournment on 15th of February again if the client doesn't come from Bangalore.
Your
If they are
Lordship,
saying so.
collect some document also, no? And I have to seek some
When your clients are
instruction.
coming back, do you have any instruction in that regard?
Yes,
When
Lordship.
your clients are coming back?
After 1 week, I guess.
After 1 week?
Yes.
We are giving them sufficient time. By the 15th of February, it is already 3-week time they are taking, my lord.
One thing, let the matter be listed on 15th of February. By that time, if you cannot get the instructions, you pray for an adjournment for 1 week, another 1 week. But if it is, the matter is urgent, suppose, we are going to submit this.
And Your Lordship, the interim order may be continued.
Heard MS Suenso appearing on behalf of T. Sunil, the learned counsel for the petition appellant, and also heard Mr. Arsona.
On behalf of Arsona, my lord.
You are Mr.
B. Nyarus.
P. Nyangi, they appeared on behalf of Mr. Arsona, the learned counsel for the respondent. It is submitted by Ms. Yaram that they are going to file the we are going to file the rejoinder. Rejoinder.
No, Your Lordship. The sole petitioner.
Huh?
Sole petitioner.
No, you're going to file the against their.
Yes, Your Lordship, yes.
We will find the rejoinder in against the affidavit in opposition filed by the respondent side, and accordingly sought some more time to take instruction from her client, and accordingly paid adjournment. Heard prayer allowed. Let the matter be listed on 15th of February 2023, enabling the petitioner side to file their rejoinder. The further the interim order should be continued till next date of this.
Deeply
Thank you,
obliged.
Your Lordship.
Your Lordship, I beg to mention item number 18. Yeah,
1-8
1H.
Ah.
We are on behalf of petitioner.
on behalf of
Petitioner. Yes. Consent has been taken.
why you need adjournment?
Uh, Conducting counsel is out of station.
The request
Uh,
of landed the request of the petitioner side.
Your Honor, Your Lordship,
Setting the ground that the learned and his counsel is out of station.
my humble
The
request
matter
would be
adjourned.
kindly fix the matter on 19th of this
The
February.
matter be adjourned accordingly. Fixing 19th.
Yes.
19th. Was there any interim? Was there any interim?
Uh,
You know?
no.
No interim. 19th of February.
Obliged.
May I please, Lordship? Lordship, this is a criminal petition filed under section 482 of CRPC, jointly filed by the petitioner number 1, 2, 3, and 4. Lordship, here in this case, petitioner number 1 and 2, they are the accused person in connection with this present case. And petitioner number 3 and 4, they are the complainant and the victim in connection with the present case. Lordship, the allegation against the accused person is that Section 353, that is restraining a public servant from discharging his official duty. 354, it is a criminal assault with a outraging the modesty of a woman. And 34 of IPC. And of course, 323, that is simple, voluntarily causing simple harm. Lordship, the fact of the case is that on 13/10/2018,
Fact of the case, do you need any or you want to go for the head?
Your Lordship.
The thing. The LCR or the cases at the.
No, yes, the motion is there, Your Lordship. First time, for the first time, this is before.
That's what I'm saying. The motion stage.
Yes, Your Lordship.
Now, whether the case has been charged or.
Yes, yes, Your Lordship. Charge sheeted. Yes, Your
Case is pending.
Yes, Your Lordship. You call for the LCR, Your Lordship. and this is-
Otherwise, most probably, there was a compromise between. the
yes,
parties.
Lordship, on the basis of compromise.
So we'll call for the LCR.
Yes, Your Lordship. Copy of the LCR.
Lordship, I have an interim prayer. It may be state.
Hmm?
The proceeding of the case may be state.
What is the stage now? Charge has been framed or?
Yes, only charge has been framed. No any prosecution witnesses. The statement has not been recorded so far. None of the prosecution witnesses.
Hard Mr.
T. Taba.
Itaba Dilane, the counsel for the petition. And also hard Mr. P.A.J. Dilane, additional PP appearing on behalf of said respondent. And this is an application under section so and so in connection with suits. It is submitted by the learned counsel for the petitioner. That case matter has already been compromised between the parties, and accordingly, they filed this joint petition for quashing of the criminal proceeding. And in that context, Mr. G.A.J. Dilanet, additional PP, has submitted that the case is at the motion stage, and he needs the LC, scan copy of the LCR will be required to hear the matter. In the same time, the further the learned counsel for the petitioner submitted that the case, the charge has already been framed and case is at the stage of evidence and accordingly pray for further stay of the further proceeding. Case number so and so state.
2 weeks, Your Lordship. Yes, yes, sir. Deeply obliged. Lordship, this is civil revision petition, Lordship.
Yes. Affidavit position. Respondent already filed?
Yes.
Your affidavit of
Yes, yes,
Right.
fine.
So, it may be disposed of today.
Pardon?
It may be disposed of today.
Yes, you can.
Yes, Lordship, before coming to the impugned order, Lordship, just I'd like to take, Lordship, the facts of the present case, Lordship. Lordship, this is eviction issue, Lordship. Eviction issue. There's a place called Zero Putu. It's at Zero, Los Angeles district. And this land was donated to the government by the local people year back in year 1952, Lordship.
1952.
52, Lordship. In regards to some portion, Lordship, there was a dispute. And in that particular dispute, there's a judgment passed by Lordship, then district court, district magistrate, is at page 15.
Dispute in the
page
sense
15.
whether there was any case was registered or any petition representation was filed before the. What kind of dispute? Dispute was there.
Yeah, dispute was there
Ah.
between the. Kindly come to page 15, Lordship.
Achha.
Regarding the ownership of this very area, Lordship, there was a dispute between the Tarukago and Lajang clan. This is one clan, Lordship. Kago, Kago, the present respondent is the Kago Yasung, Lordship. He belongs to the Kago clan.
Kago clan.
And this clan consists of 3 clans, that is Tarukago and Lajang clan, Lordship. Between the all Zero Bajar committee, because Zero area, they have a Bajar committee, and there was some dispute, Lordship, regarding the ownership of this area. Yeah, because it's being controlled by the budget committee. So I think there was some dispute. And in that regards, Lordship, this very decision has been rendered, Lordship. Kindly come to page, Lordship, page 19, Lordship. The operating portion, Lordship. Page 19.
Yes.
It is therefore decided that the land in question, which was donated to the government in year 1952, belongs to the government and claims by Tarukago Lajang clan and all Bajar committee Zero about the ownership of the land is not tenable. The number one, Lordship, both of them, they are not the owner of this land, Lordship. It has been donated to the government, and government is the sole owner of this very land. The claim of the Tarukago clan, Lajang clan, is not maintainable. That their ancestors were illiterate, so they donated the land. Their claim, which came up only 2 years back, does not corroborate their claim once they admit that the land was donated to government 50 years back. Now, it was donated 50 years back, only they were illiterate. That was the dispute there, Lordship. there would not be any official donation as claimed by Tarukago Lajang clan, as it would invite claims from various quarters after the lapse of 50 years. Once the ownership of the land is decided, the owner has sole right to allot any portions of land as it is done in Hapuli area also, which was donated by people in the past. No claim or objections against the legal allotment of the land would be entertained. Now, lordship, by this very judgment, lordship, this very area has been lordship declared to be a government land. Otherwise, also it was lordship in 1952. It was donated to the government lordship. Now, lordship, so far the government land is concerned, lordship. How lordship it becomes a government land? One is by way of acquisition, lordship, under the Acquisition Act. Other one is by way of lordship donation. If it's voluntarily donated by the private person, then it becomes the government, as per our land records law, lordship. And in the present case, lordship, what happened? The present respondent encroached over the switchyard area. Switchyard means lordship, the power department, the switchyard area. They encroached and they erected the OBT type lordship, ordinary bamboo type lordship, house lordship. And kindly come to next page, that's page 20, lordship. So-cause notice was issued under Arunachal Pradesh Public Premises Evictions of Unauthorized Occupants Act 2003 lawsuit. Here lawsuit, the respondent has been directed to so-cause as why he shall not be evicted from this very area because he has encroached over the switchyard area lawsuit all year. Then lawsuit, kindly next come to next page. This is the second so-cause notice lawsuit. Notice to so and so. Whereas a so-cause notice has been issued on 29/8/2013 regarding encroachment of land and directed you to so-cause in writing on or before 13/9/2013. Whereas your so-cause reply has not been received till date by this office. Therefore, you are hereby directed to appear before State Officer 0 in this office chamber on so and so without fail. Down below, lawsuit will find the respondent has received a copy lawsuit received by Kaguya. Then thereafter, there was no lawsuit appropriate lawsuit reply. So then kindly come to page 22 lawsuit. What is complaint dated was received from the chairman so and so in so and so. Whereas so-cause notice were issued to all the 33 encroachers under section 6 and 7 of Arunachal Pradesh Public Premises Evictions of Unauthorized Occupants Act 2003. Whereas some of the encroachers have replied the so-cause notice. From the reply, it has seen that these encroachers have occupied the government land without any government allotment. Therefore, the representations of the illegal encroachers of government land in all 042 and Suluya area are hereby rejected. Therefore, for the region cited above, all structures constructed by the 33 encroachers will be evicted, demolished under section so and so within 1 month of the date of issuance of the order. Therefore, all the encroachers are hereby directed to remove their illegal structures from the old 042 and Suluya within 31st December 2014. Order passed under my so and so, and this copy also has been received by the respondent lawsuit fine received by Kaguya-san lawsuit. Now they have been lawsuit directed to vacate within a month. Then lawsuit, what happened? This very order, the eviction order, has never been challenged lawsuit. Otherwise, lawsuit under this eviction law lawsuit, under section 12 lawsuit, there's a provision if anyone is aggrieved by the order passed by the estate officer, then the appeal can be filed before the lawsuit deputy commissioner. That provision is there under the appeal. Since it has not been challenged, it attained the finality. Now he has been directed, he has been held to be an illegal encroacher and directed to be removed, else evictions will be carried out lawsuit. That is the final order lawsuit. Then this very order, though it has been received by her, it was not lordship complied with lordship. Then what happened, lordship? On 13/7/2015, 13/7/2015, it's almost after 9 months, lordship. Eviction has been carried out. Eviction has been carried out. Now matter ends, dear lordship. Then kindly come to page 23, lordship. The respondent, what he did is, she filed one money suit, lordship. Money suit before the lordship civil judge, senior division 0, lordship. Against the state government, lordship will find the respondent number 1 is the Union Government of India, represented by Chief Secretary Itanagar Arunachal Pradesh. How is possible? I don't know, lordship. The Deputy Commissioner, District Lower Subsidy 0, so and so. Superintendent of Police, District Lower so and so. Estate Officer, Land Revenue and Settlement Officer. And prayer is 8-page, lordship. Page 27. Admit this plain and issue notice to the respondent. Hear the parties and summon witnesses and evidences. Pass a decree to award of compensation. Pass an order for award of damages and costs in favor of the plaintiff. Now, lordship, because eviction has been carried out, lordship, what the respondent is asking is for the compensation, lordship. Now, compensation against whom, lordship? Compensation against the government, lordship. Now, whether the petitioner, respondent is entitled for the compensation or not, that's the issue here, lordship. Then I'm taking lordship to the this very law, that is volume 8, AP code volume 8. Kindly come to page 160, lordship. 160. This is Arunachal Pradesh Public Premises Evictions of Unauthorized Occupants Act 2003, lordship, under which, lordship, the eviction was carried out. Relevant is, lordship, section 19 and 20, lordship. At page 172 and 173.
19 and 20.
19 and 20. Lordship, two types of lordship protection has been given to the lordship state authorities under this act, lordship. One is lordship 19. 19 is at page 172, lordship, bottom. No court shall have jurisdiction to entertain any suit or proceeding in respect of the evictions of any person who is in unauthorized occupations of any public premises, or the removal of any building, structure, or fixture, or goods, cattle, or other animals from any public premises under so and so. The demolitions of any building or other structure made or ordered to be made under section 7. Sealing of any erection or work or of any public premises under section 8, or the arrears of rent payable under subsection so and so of section 10, or damages payable under so and so, so and so and so and so. The recovery of cost of removal of any building is so and so, so and so and so. Expenses of demolition under section 7, costs awarded to the state government, also and so and so and so. These are the lordship bar of jurisdiction on this subject, lordship. The civil court cannot take up. Only the lordship state officer or the appellate authority provided under this. Then kindly come to the lordship, section 20. Lordship. Hmm. 2020. No suit, prosecutions or other legal proceedings shall lie against the state government or the appellate officer or the state officer in respect of anything which is in good faith done or intended to be done in pursuance of this act or any rules or orders made thereunder. This is protection against the officials, the authorities. Here, lordship writings are protections of action taken in good faith. Now, the state government and the authorities, the officials, they have been lordship protected under these two provisions. This particular suit is not maintainable because of these two provisions. Firstly, lordship, why the eviction order has to be held illegal first, because they attain the finality, respondent choose not to appeal that very order lordship. That has not been held as illegal lordship. And even if it has been held illegal also, now the respondent has to prove and place before the court that it has been done with intention of lordship malafide, not done in good faith. Illegal along with mensia also must be there, sort of mensia, not in good faith. Simply lordship illegal is not sufficient. Lordship. If lordship come back to the page 23 lordship, the very plain, the suit lordship filed by that. Here lordship will find nothing allegation of that sort lordship has been made against the state government lordship. Even if it's raised also lordship, if lordship will find only one paragraph lordship, paragraph 5, that is at page 25 lordship.
Yes.
Page 25 lordship, paragraph 4 and 5 I would like to read lordship. On 13 so and so, as per so and so, she says OCPS 0 have illegally, abruptly, and recklessly demolished the house, including properties, pixie and vegetables of the garden by engaging JCB. The plaintiff was not served with notices or order under so and so. The eviction drive was hard to be carried out at 042. However, plaintiff house and garden was at Kundo and not a part of 042. Hence, this compensation suit for illegal damages. Humble plaintiff submits that demolitions of her property was not done in accordance to the honorable so and so, but it was done under illegal pressure put to DC by Sri so and so, Secretary Old Zero Market so and so. These are the only two allegations that has been raised against the plaintiff. Now, my lordship submission on this very issue is I'm repeating only. Had it been the illegal lordship, eviction lordship, the respondent could have go for appeal lawsuit, and that has not been the lawsuit. That has been finally. In response to this very short lawsuit, we the state file written statement. After eviction has been held to be illegal only lawsuit, now the questions of compensation can come lawsuit, otherwise not lawsuit. In response to this very suit lawsuit, we file our written statement. We raise maintainability of the suit also. And the learned trial court did not consider that very lawsuit, the maintainability on law, because this is maintainability on law lawsuit. And preliminary issue should have been framed to hear on that. It was not hard. Then we file one IA lawsuit. IA raising the maintainability of suit again lawsuit, repeating, so that appropriate order can be passed lawsuit. Now this is the impugn order. Kindly come to page lawsuit. 45 lawsuit.
Page?
Page 45. 45. we file IA lawsuit. IA that's misapplications number 50 of 2018, raising the maintainability of the suit lawsuit on this ground, section 19 and 20 of the this Eviction Act lawsuit. Lawsuit, I'll read from the third paragraph lawsuit. I'll read from the third paragraph lawsuit. The Learned Council for the Dependents has raised the maintainability of suit on the ground that the act of dependent is protected under ownership of its public premises, eviction so and so, 2003. It is also claimed that the plaintiff has right of appeal under said act before the appellate authority against the order of eviction and notice, but the plaintiff did not prepare any appeal in the light of provisions under said act. The Learned Council for the plaintiff has sought time from time to reply the point raised by the Learned Council for the dependent. Finally, finally, the Learned Council for the plaintiff submitted the notifications dated to the 27/25 empowering all the SDOs oblique EACCO holding the charge of subdivision circle as estate officer and to exercise the duty under the said act. It is therefore claimed that the estate officer cum ADC headquarter Hapoli 0 do not jurisdiction to evict the plaintiff as it comes under the jurisdictions of 0 circle all 0. Heard both the sides, produce the case records and also relevant notifications. As per the records, all 0 headquarter is circle headquarter was notified on 2/2/2009 and the same was upgraded to SDO in 2013. The eviction was conducted by the dependent on 13/7/2015. Considering the above facts and circumstances, I do not find that the case is hit by the provisions of Arunachal Pradesh Public Premises as Privilege Act, since it does not come within the territory jurisdictions of estate officer cum ADC Hapoli. The notification dated 2/2/2009 was already imposed and thereby the CO headquarter of all 0 is automatically becomes the estate officer. Therefore, the dependent estate officer cum ADC Hapoli has acted beyond his jurisdiction and same cannot be protected under the said act as privilege. In view of above, the miss case number so and so, raising the maintainability of the suit is rejected. The case shall be per so and so, so and so and so lawsuit. Now, lawsuit, in response to our IA lawsuit, the respondent, the present respondent, they file a reply lawsuit. In their reply lawsuit, they have not lawsuit raised all this issue. But at the time of hearing, they placed these notifications of 2009 and 2000 lawsuit, 13 lawsuit. Here lawsuit, what the learned trial court said is lawsuit. Earlier lawsuit, the estate officer was, power of estate officer was given to the ADC Hapoli lawsuit because that point of time lawsuit 0 CO was not created lawsuit. After a circle has been created at 0 and after it has been lawsuit upgraded to SDO in 2013 lawsuit. The only CO or the SDO of the 0 has the power and ADC of the Hapoli area do not have that power. That is the lawsuit, the observation on which lawsuit our issue of maintainability has been rejected lawsuit. Now, kindly come to lawsuit page 47. Next page, lawsuit 47. Lawsuit, this is the power comparing to the concerned officials, the power of the estate official lawsuit under this section 3 of Arunachal Pradesh Public Premises Act lawsuit. Lawsuit will find at serial number 6 lawsuit. This is notifications of 2003 lawsuit and serial number 6 Additional Deputy Commissioner 0, Lower Subansiri District Lordship. Under this very notification Lordship, ADC 0, Lower Subansiri District has been given the power of estate official Lordship. At that point of time, this entire area comes under this 0 only Lordship. All. Then Lordship, kindly come to next page Lordship. This 2005 notification Lordship. The government is pleased to further appoint all SDOs, EAC, COs holding charges of subdivision circles dealing with land related to matters as estate officer. Such officers shall exercise the powers conferred and perform the duties imposed on the estate officer by or under the said act in respect of public premises in their respective jurisdictions Lordship. By this 2005 notification Lordship, earlier Lordship, the ADC only was given the power Lordship. By this 2005 notification, all the SDOs Lordship, EAC and COs Lordship, who are in charge of that particular locality or area, they have been given the power of estate official Lordship. Now, may I take Lordship to the page page Lordship 5050 Lordship.
50.
50. Sorry. Before coming to 50, 49, previous page, 49. This is the creations of the circle. It is for general information to all concerned that the office of the sub-divisional officer, SDO 0, will start functioning very soon, likely from 3rd June 2016 for is I think for public residing in villages of 0 play 2. The villages that comes under the 0 by notification number dated 2nd February 2009. Lordship, this 0 was created as a circle in year 2009 Lordship. Though it was created in year 2009 Lordship, but no officer was appointed because it was not given effect to Lordship. Then Lordship, kindly come to next page Lordship, 502. In the interest of public service, the Governor of Arunachal Pradesh is pleased to upgrade all 0 CO headquarters to SDO headquarters with immediate effect from administrative convenience law. The administrative jurisdictions of SDO headquarters shall be the existing area of CO headquarters law. By this Lordship, 2013 notification Lordship, CO circle has been upgraded to SDO Lordship. Though it has been upgraded in year 2013 Lordship, but no officer was appointed. No circle officer, and it was upgraded to SDO division Lordship. Then again, it was not given effect to them. Now, kindly come to page 51. This is 18 September 2015 order Lordship. The charge of SDO headquarters all 0 has been allotted to Sri Mokar Riba EAC 0 in addition to his normal duties with immediate effect until further order Lordship. This is the past order Lordship by which Lordship one officer has been given the charge of SDO 0 Lordship. Not prior to no officer was given Lordship any charge, or this notification was not given effect to Lordship. Now, eviction order was passed in year 2014. Eviction order was passed in 2014. By then, there was no officer at 0 circle or SDO. An eviction has been carried out Eviction has been carried out in July Lordship 2015. 13 July 2015, eviction has been carried out. And this, the order lawsuit, it was lawsuit passed in 18 September 2015 after eviction has been carried out. After eviction has been carried out, this the headquarter has been given the circular of headquarter creating the SDO division has been given effect to, and officer has been engaged lawsuit. Unless officer is appointed lawsuit, then no one was there lawsuit. This all aspect has not been considered lawsuit, and even opposition was not given lawsuit. This was not, it was not even part, because records is available before this one court. It was not even part of their reply lawsuit. It was just placed at point of lawsuit hearing, and on basing on that lawsuit, it has been passed. Whether officers appointed or not, all those aspects have not been considered. Now, lawsuit, in reply to our this very civil revision petition lawsuit, my friend has filed lawsuit, the respondent has filed their reply lawsuit, the affidavit, and they have not denied lawsuit, all these aspects, that no CO or ESC was appointed. That has not been denied. Now it remains lawsuit true that officer was appointed in year 2015 only, that is after eviction has been carried out. So this is my case lawsuit basically. And my case lawsuit basically is, apart from that, is that lawsuit. So far, protection is provided under this section 20 lawsuit. Until unless lawsuit, any sort of lawsuit allegation is raised. First lawsuit, if eviction is carried out, first that order has to be held as an illegal lawsuit. And who has to decide whether this is government land or not? Whether it has been illegally, lawsuit, eviction order has been passed or not. If whether this is government land or not lawsuit, estate official has to decide lawsuit. And they have not lawsuit challenge that order. Secondly, lawsuit, whether the estate official has lawsuit illegally passed that order or not. They could have raised this issue before the appellate forum. They could have challenged this very order of eviction, that eviction order is illegal and it has been passed lawsuit without there being a good faith lawsuit. But they choose not to file appeal, and consequently lawsuit, this eviction order became attain the finality lawsuit. So therefore lawsuit, the order of the impugn order passed by the learned trial court is not correct lawsuit, and I'm praying for the interference. That's all.
But basically the question is that it was a donated land to the government, and the government, it was under the government land. It was the government land. Government land in 1952, it was donated by that clan.
Clearly.
But the question is that for the donation, suppose subsequently they have any scope for praying for any compensation on that land, even if suppose it was a donation.
That is completely another
issue.
Another completely, not even lawsuit connected to this issue. Here lawsuit, they are not asking for
But basically they have-
compensation in regards to the land lawsuit. They are asking for the illegal eviction lawsuit. The action which we have done lawsuit, for that action lawsuit, that action is illegal. Therefore, you are supposed to pay the compensation. That's their lawsuit, fair lawsuit.
Yes.
I have submitted my argument points. Can you take me to report?
This is a written argument.
Yes. Lordship, in this case, the case as projected by the learned State Council is a bit different from the actual case. Because the extent I have taken in this point, Your Lordship, is that I'm contesting this case on two grounds. The first ground is that it is a private land. It doesn't come under the government land. It is the first ground. And the second ground is that even if it falls under the government land, then also the eviction is illegal. These are the two grounds I'm taking. Now, coming to the first point, that my land is a private land. Your Lordship, in my place, the place in question is the Zero Putu. Now, Zero is the name of the place, Your Lordship is aware, and Putu means hill, which means there's one place, one hill called Zero Putu. So that is the issue here. Now, they are saying that Zero Putu has been donated by the people in 1952. That point is not the issue here. That point I'm not contesting. That is very clear that we have donated the land and I'm not claiming it part. Now, the Zero Putu is a hill, and the areas below the Zero Putu, they are known by different names, like Kundo, Kudung Barang, Kano. They are known by different names, the areas below the Zero Putu. And the claim I'm raising is that my area falls below the Zero Putu, which is part of an area called Kundo. It doesn't come under the Zero Putu. Now they are just raising the area of Zero Putu, which I'm not contesting at all. Now, since my area comes under Kundo area, not the Zero Putu area, so it is a private land. And
Your land comes under Zero?
Kundo. Kundo. It is near the Zero Putu, but it doesn't come under the Zero Putu. That is my claim.
And not under Zero?
Zero Putu. Zero Putu. Putu means hill, also. The land that has been donated.
So you don't have any dispute that the land which have been donated from Zero Kundo is not disputed?
Zero Putu, that is
But
not
the
disputed.
question is that the land which belong to you it falls under
Kundo.
Zero Kundo. That was your private land.
No, the land Zero Putu being donated, that is not disputed.
That is not disputed. Yes.
Now, my land, it comes
Falls
under
Zero Kundo.
Kundo, yes. Not it's only Kundo, not Zero. It's only Kundo. Yeah. So it doesn't come under Zero Putu. That is my
It is your private land.
yes. That is what I'm claiming. Now, since it comes under Kundo and doesn't fall under Zero Putu, which has been donated, so it is a private land. It is not a government land, and they cannot say that this falls under Zero Putu, so it is a government land. That is my first issue. Your Honor. Because below the Zero Putu, below that hill, the areas are known by different names. Like I have Kundo, Kudumbar, and different names. And so my land falls under Kundo area. Now, if the state is saying that their act has been taken in the government land of Zero Putu, they have to first prove it by bringing the witnesses. It has to be first decided whether the act was carried out in the private land or in the government land. It has to be first decided. That is the first issue. And whether the act was carried out in the private land or in the government land, it can be decided only in the trial court, Your Lordship, by proper examination of the witnesses, not simply relying on one old documents which has been donated. It cannot be decided only on that documents alone. The issue whether the act was carried out in private land or in government land, it can be decided only by the trial court, Your Lordship, by proper examination. So their issue of the question of raising the mentability is liable to be dismissed on this ground itself, Your Lordship. Now, because this court cannot peruse the witnesses, it can be done only by the trial court. Now, second issue, Your Lordship, is that even if it is assumed that it falls under the government land, let's say for time being that it is a government land. Now, even if it is assumed that if it is a government land, then also, Your Lordship, their act was illegal. Now, how it is illegal? The first point is, Your Lordship, now, in order to evict a person from a private government land, a notice has to be served first. Now, the estate is saying the notice has been served to me, but this is untrue. They have given false submission that the notice has been served. Now,
So you also deny that two show cause notices were issued to you. That's
yes,
true.
that is not served to me. That is my
That is
first.
not true.
That is not true. Now, may I please take Your Lordship to page number 13 of my affidavit, Your Lordship? This is the letter by the DLRSO addressed to the Public Information Officer for the RTI documents. Now, in response to this letter, the the OCPS 0 they have filed one reply, given on reply, which is in page number 14, Your Lordship. And type copy is in page 15. May I read you? Page 15, Your Lordship. Subject, returning of unserved notice. Sir, refer your letter number so and so, dated so and so. I'm returning here with the unserved notice paper issued against Tusi Kago Yasung, daughter of Kago Taring of Hiza village. The region of unserved notice has been reflected in the backside of this notice paper. Submitted for your kind information and further necessary action, please. This is the reply given by the OCPS 0. Now, this clearly
Region
shows.
of unserved has been reflected in the backside of the notice.
Yes, but that I don't have. The backside of the page I don't have.
Backside of the page,
That I don't have.
you don't have.
No. But the front page I have.
How can you say that?
You see,
You
if you
don't
look
have
at the,
the next page.
then
On
next,
backside of the page, you don't have.
yes.
Then?
But here it clearly says that the notice has not been served to me. I am returning here with the unserved notice paper issued to Srimati Kagoyasung, which clearly says that the notice has not been served to me, Your Lordship. Now, Your Lordship, please come to page number 13, Your Lordship, of my affidavit. No, 12, 1, 2, 12.
1 third.
It's page number 12
Oh,
of
12.
my affidavit, Your Lordship. Here, Your Lordship will see the sign given by me. I have given my thumb impression. This is one point. Now, why I am pointing out this case is because, Your Lordship, I'm illiterate. I cannot sign at all. This is my path. Now, look at the notice that has been served to me, which is at page number 16 of my affidavit, Your Lordship. And 17 Your Lordship both. Now it is written received by Kagoyasung. And even the 17 Your Lordship, here also received by Srimati Kagoyasung. Now when a notice is served, the person who received the notice, he has to give his or her signature. But here I don't know who has given the signature, whereas I am an illiterate. Now if your Lordship peruse it properly, you will see that even the signatures are the way of writing the signature is very different. Your Lordship, ma'am, please take some time to look at the difference. So the difference in signature, Your Lordship, the way they have written. So it clearly shows that it has been written by some, I don't know who is, by some other persons, and they have misled this court by saying that the notice has been served to me. Now, going by this fact that they have given false documents, in fact, they are liable to be taken with us for misleading this court, because the notice has never been served to me, and they have given some false signature of me. That is my first issue. Now, the second issue, Your Lordship, if we look at the notification 2005, which I have annexed in page 18 of my affidavit, the same page was pointed out by the London State Council also. Yes, yes. May I please read? In exercise of the power conferred upon section 3 of the Unauthorized Public Premises Eviction of Unauthorized Acquisition 3, the governor of Arunachal Pradesh is pleased to further appoint all SDOs, ESCs, COs holding charge of subdivisional circles dealing with land-related matters as state officer. Such officers shall exercise power conferred and perform the duties imposed on the state officer or by under the act in respect of the public premises in their respective jurisdiction, Your Lordship. So this notification 2005 clearly says that in their respective jurisdictions, they will be holding their power in their own jurisdictions. So this clearly says that the person of one jurisdiction cannot exercise jurisdiction over the other area by this notification.
His submission, he submitted that the Mr. Kapil has submitted that.
Yes. Now, then the notification 2009 Your Lordship, Your Lordship has seen this just right now where zero has been created as a separate circle headquarter. And then the notification 2013, where it has been upgraded to CO, I mean SDO office. Now, if he says that no officer has been appointed, then there has been one standing order, which is because of the non-appointing of the any officers in the respective area, this so and so is allowed to continue the jurisdiction of that area. Then how is the notification? There's no such notification which allows them to further hold the charge of that area, of the separate area. So their contention that since no one was appointed, so we still have the control over the jurisdiction. So that point cannot be raised. Because if they are raising that issue, then there has to be one proper standing separate notification which says that, which empowers them to further continue to hold the jurisdiction of that area. So on that ground also, the act of the state officer Hapoli is illegal and wrong. So it was on that ground that Your Lordship that the learned civil judge Zero, he has rightly observed that they have acted beyond their jurisdiction, and it cannot be taken as a matter of privilege. Now, so because of the observation and the points I have read, it will be just in the interest of the law that the other parts of the learned civil judge should be upheld. No, therefore, you on the grounds of all the points I have submitted, my prayer is that the other parts for the landed civil judge may be upheld, and this matter may be dismissed, and the matter will be further remanded back to the civil judge Zero for further trial.
Small clarification regarding lawsuit whether this is a private lane or government land. Yes, again, I'm repeating lawsuit whether this is a private lane or government land. This is state official is the authority to decide lawsuit or appeal to authority. They have not lawsuit raised this issue before the authority concerned. And so far, lawsuit this is one issue lawsuit. And if lawsuit see the page 24 of the reply filed by my friend lawsuit. Kindly page 24. This is very pertinent. Annexure 7 is the affidavit filed by the.
Yes.
This is sketch map lawsuit, zero area lawsuit. Lawsuit will find left hand side this document. Power department switchyard is given here. Bottom. Switchyard. So lawsuit, I have taken lawsuit to the notice, so-called notice lawsuit. The allegation is that lawsuit he has encroached over this switchyard area lawsuit. Now my friend himself he has lawsuit annexed this sketch map. This switchyard area definitely comes under lawsuit 0.2 area lawsuit. This is the lawsuit sketch map of 0.2, and switchyard comes under within the 0 foot, not in even in the boundary lordship, very inside the lordship. So this is the sketch produced by my friend lordship. And that's two issue lordship. On facts also it comes under the government land, and on law also lordship, this issue should have been raised before the estate official or the lordship. And secondly, so far notice is concerned lordship, my friend lordship, so far returning of the notice is of lordship 2015 lordship, October 2015 lordship. The so-called notice was issued to her in year 2013 lordship. Two so-called notice, which I have taken lordship. So I think that notice is something, another thing which I think my friend. So, and that is one thing lordship. Then another thing, jurisdiction is concerned lordship. Additional deputy commissioner, as per 2003 notification lordship, additional deputy commissioner is the lordship, the estate officer for the entire zero area lordship. Entire zero area. And this AD has been continuing the lordship that power, because there was no appointment of lordship SDO or CO lordship. It's not about the lordship any alteration is there lordship. Until unless lordship any new official is appointed after circle or SDO has been created lordship. It's about the continuing of the lordship, continue exercising of the power only lordship. So until unless charge is handed over to, after appointment charge will be handed over, then only he will take up the lordship, the jurisdiction lordship. So this is my reply to that lordship.
That is not the case, Your Lordship. As regards to the notice of the unserved notice, it is mentioned 2015 because it is just a reply to RTI. So it is just a reply of the RTI date, not the notice. And regarding the appeal as submitted by the State Council, now the question of appeal will come only when I have been served a notice. And in the absence of being any receipt, where should I go for appeal? I cannot go for appeal without receiving any notice. That is one issue. And another issue is that now since the separate headquarter has been created, now the further previous estate officer, he cannot automatically see that I still have the jurisdiction in the absence of any standing of further notice. That's all, Your Lordship. I humbly request that the other parts of the decision may be upheld.
Mr.
Yes.
Corresponding. 60 matter for hard deadline, 60 matter for order on 30. I pass the order on
Close.
38.
All right.
Your Lordship.
उसको भी रख देना 5 घंटे yes.
Here, my lord, notice was issued and the private respondents have engaged a set of counsel, but they are not appearing.
Council is two name of two council are
Yes,
reflected.
yes.
Let us give one more chance then. Objection not yet filed anyway. They have an appeal. The last revision also same.
Yes, so going on for a long time. One last chance, my lord, thereafter also.
Now, the name of here.
Mr. Bodi is there
Bodi is there and.
and Lapu is there.
I don't know.
My lord, will fix a next date. I will inform Mr. Bodi. He appears, otherwise.
Mr. Dipanu, the counsel for the petition. The previous no one represented the respondent side. However, from the positive, that reveals that name of two counsel are being reflected in the policy. from the orders, it also reveals that in the earlier occasion also, both the councils are remaining absent and has not represented the respondent side. However, later one more chance be given, fixing. Yes, any after 2 weeks or 3 weeks? After
2 weeks,
2
ma'am.
weeks. 2 weeks. Let the matter be listed after 2 weeks. Can I reflect that you are going to know? It should not be. It should not be ideal. But probably
I will.
yes.
That will be interim.
Interim was there. Interim be continued till link date of this.
Okay.
Yeah, Lordship.
Yes.
Lordship, item number 5, 6, and 7 are analogous matter.
Item number 5, 6, and 7.
Yes, Lord.
Arising out of same FIR, and they are the alleged accused. On last occasion, Your Lordship has called for updated case diary pertains to the statement given by the other co-accused, and their statement has been recorded, Your Lordship.
Honorable Court.
Otherwise, in all the cases, you are on interim.
Yes, Lordship. By order 1912 of 2023, I was granted
It is
interim.
it is continued. And so, who are the other witnesses? I'm not following you.
Your Lordship, 3 alleged accused are there, although they are not named in the FIR, but 3 persons who are engaged in the altercation, Your Lordship, and they have been assaulted by the firewood as per the case diary, Your Lordship, not by the this lethal weapon, Your Lordship.
These persons who are appearing in this cases,
Yes. Your Lordship.
their statements are already been recorded.
Yes,
by
Your
now.
Lordship, recorded is now before. Earlier, a statement of the two co-accused were not recorded, but now it's already been recorded. Yes, Your Lordship.
Yes, any other submission from you?
Lordship, my submission will be, since their Lordship, the statement has been recorded and their one 10,000 has been executed before the investigation officer. Lordship, their arrest will not be necessary, Lordship, so this interim may be made absolute. In fact, Lordship, in this matter, they are the
It was a case under section 326.
326, Lordship. This is a counter FIR given by the the complainant. Actually, Lordship, here what has happened in appellant, I was assaulted by them, Your Lordship. I had given an FIR. That FIR.
Who are you? Your name is now? The 3 accused, no? That's right.
Yes, Lordship. The first-
GK?
GK James.
Huh?
GK James. That is-
GK James.
Yes, Lordship.
As per you, the GK James was assaulted.
Yes, Lordship. Yes, sir. With that, Lordship, I've annexed my photograph, my medical admitted. And Lordship, the FIR which I have lodged against the complainant, that has been registered under 341, 325, 326, and 334. And Lordship, I have made the
341, 325,
326.
Okay.
And I had lodged the FIR on 9/4 of 2023. And in this instant case, Lordship, they have lodged after a gap of 1 day. They have lodged it on 10/4 of 2023. Instead of registering after registering my case, they should have ought to have arrested the complainant, but they have registered the complaint, taking cognizance of that and registered a case against me under 326, which is a counter FIR. Yeah, Lordship, I would like to take to page 15. That is annexure 3, the complaint given by me, Lordship.
complaint given by you.
Yes, Lordship. And before that is the page 14 is my page 15, Lordship. May I read, Lordship? It says to the officer in charge, Papu Hill Police Station, FIR again, so and so, and that so and so, that is and 2 other persons. They are the complainant in my respected sir. In inviting your kind intention to the subject cited above, I would like to inform your authorities that around 2:30 a.m. that is 9/4 of 2023 at Papu Hill, Papu Nala Street, so and so, and 2 other attacked me and my friend, namely GK James, that is the petitioner number 1, by wooden wood stick, and also attacked to murder me by knife, which has caused severe injury to me and my friend, so and so, who is completely hospitalized and admitted at Prince Hospital. That when me and my friend so and so went in charge of water and some grocery item in the shop, opposite to Bharat Petroleum Pump at Papunalan. We then see so and so, without any reason began to attack, physically assaulted me and my friend, so and so, for which led us into physical injury. That we do not have any enmity with any person. However, they attack us at around 2:10 a.m. So and so was purely done by an evil motive. Therefore, we pray. This was the FIR lodged against by me and my friend. Like, since we had attacked on 9/4 of 2023. So this case was registered under 341, 325, 326. And after this lordship, which I am before this honorable court, they have lodged against an FIR against me also lordship. That is in lordship, page 21 is the type copy lordship. So I'm before this honorable court against this FIR lordship, page 21 lordship. May I read lordship? This FIR was given on
It's okay, but the question is when the informant of your case is one Dana Taruj. Was he is also accused in the complaint filed by you? No.
Yes, lordship, and two others.
Dana?
I've given
You
Dana,
have
Tena,
named Sri Dana. Achha. No, not Taruj is there. One Dana, Penba and Sri Dana
Tasa, and two others.
Tasha. Dana Taruj was not there.
And two others, since I don't know their name, but I have given and two others. That page 21 is the complaint lodged by them. May I read on? It's in the type copy is in page 21.
Yeah, I understand that you have written and they in a counter or whatever
Yes.
they have also
Lodged.
filed an FIR against you. Yes.
Since your lordship, their statement has been recorded and I've gone through their statement, it was a sudden fight, your lordship. So, your lordship, perhaps their custodial interrogation is perhaps not deemed required, your lordship. They are cooperating with the investigation.
So I have seen 5, 6, and 7 are there. One in 5, GK James, he is also a victim.
Yes, lordship.
Victim,
Yes,
and he lost the FIR.
Yeah, no, his friend, the other one who was not injured, like he was that
Tasso?
one. Yeah, Tasa,
Yeah, he lost the FIR.
he lost the FIR.
The FIR lost by you. That means he lost the FIR
Yes,
against the complainant. And other one, Yakar, he was a victim or no?
You know, he wasn't just an onlooker. He was seems like I have even given a Eberman in my.
Oh. Mr. B. Yeah, I think number 5, 6, and 7. Listen, young. 5, 6, and 7 almost same. Heard Mr. B. Jammu, the learned counsel for the petition, also heard Mr. activated the learned additional PP appearing on behalf of state respondent. This is an application in section so and so and punishing the CD receipt, paid same, heard also. It is submitted by the learned counsel for the petitioner that after obtaining the interim period is bill on 19/12/2023, he appeared before the IO and cooperated in the investigation of this case. His statement is also recorded by the IO in the section 161 CRPC. Further, he submitted that the present FIR is filed as a counter FIR as the counter FIR and the against the counter FIR as they have already filed an FIR against the present informants as complainant and two others on 9/4/2023 after they assaulted the present petitioner and two others.
This may be recorded, CD may be returned, Your Lordship, in the order itself.
Deeply obliged.
Deeply obliged, Your Lordship.
5, 6, and 7 almost same.
My lord, I have seen the record, Your Lordship, where the service report in respect of respondents are still awaiting. And
Service report for respondent.
Lordship, private
It's a
respondents.
POXO case, Your Lordship.
Still POXO case. Otherwise, the present accused person is
Lady matter will be listed on 7,
Lordship.
7, 5, 7, 2 to 10.
Your Lordship, scan copy of the LCR.
Yes. Send the WT then.
Yes, we'll send, definitely, Your Lordship. Let them take steps, Your Lordship. Deeply obliged.
Please, Your Lordship.
Yes.
Lordship, pending arrest, this bail application has been moved. And my lord, the applicant before Your Lordship is a retired government, my lord, the officer, is Deputy Director, School Education, my lord,
Deputy Director
of School Education, my lord, DDSC, my lord. He is a retired, my lord, DDSC,
retired person.
my lord, retired person. And my lord, the FIR is at page number, my lord, 18, written FIR, my lord. Page number 18, my lord. The FIR against the membership illegal appointments of the PRT and the MTS at Sian districts under the Department of the Education as per the termination order by issued by the Commissioner Education, Government of Arunachal Pradesh. From reading of entire contents of this FIR, nowhere disclosed against this present petitioner applicants. If may I read, the
Your
with
petitioner's name is?
my lord,
Your petitioner name is?
name is Talem
Talem.
Jamo, my lord, retired
Talem.
DDSC, my lord. And the my lord, allegation is also, my lord, the illegal appointment, my lord, that illegal appointment, the SIC case pending, and the my lord, illegal appointment, the illegal appointees has been already terminated, my lord. I was serving the my lord as DDSC, my lord, before my retirement, my lord, but nowhere, my lord, disclosed against the my lord, the offense, my lord, that the alleged to be committed by me, my lord. My lord, it is in respect of the my lord, that is one aspect, my lord. Nowhere disclosed, my lord. Another, my lord, if ever, even illegal appointment is made, my lord, I don't have any, my lord, the direct connections with those illegal appointees, my lord. That's because I am the deputy director serving in the district. My lord, appointment order has been made by the, my lord, the director elementary education at higher level, my lord, at my lord, government side, my lord. So therefore, I have enclosed a copy of the my lord, the appointment order also, my lord. Appointment has been made by the, my lord, the director of elementary education, Government of Arunachal Pradesh, but not by me, my lord. Of course, my lord, these appointees were fostered at my office, under my office, my lord. Since some of them has been fostered in my office, some of them has been serving under my jurisdiction by virtue of, my lord, the deputy director of school education, my lord. Basing on this, the apprehending, on the strength of this, purported FIR, case has been registered. And apprehending that arrest, I moved this honorable court. And this honorable court was pleased to, give interim protections, on 5th, on 5th of this month, and this honorable court, by the interim order, directed me to appear before the IO of the case on within a period of 7 days, accordingly, I appear before the IO of the case, and additional affidavit which I have filed to bring on record, on by by additional affidavit, my lord, I appear before the, my lord, the IO of the case on 8 by filing applications, my lord. My lord, my lord, without going into the entire, my lord, details, my lord, just I'm, my lord, placing the, my lord, the relevant records, my lord, by as per the direction of this honorable court, I appear before the, my lord, IO of the case on 8 January 2009 January and 12 also, my lord. On 12, my lord. On 3 occasions, my lord. Sorry, 3 occasions, I appear before the IO of the case. And my lord, the statement has been recorded. Even I have furnished the, my lord, entire bank, my lord, details, even Aadhaar card, my lord, all other relevant, my lord, information to the IO of the case, my lord. Therefore, my lord, since this is the interim, my lord, the bail, my lord, at this stage, my lord, since the CD has been called for today, my lord, may I pray that, my lord, the interim bail may be made absolute, my lord, subject to the submissions made by the, my lord, the other counsel for the other party. My lord, since there is no requirement of the custodial interrogations, my lord, as because, my lord, I have given my the statement, I'm cooperating with the IO of the case. Even, my lord, I'm ready to cooperate, my lord, as in when even some documents is required to be, my lord, I'm ready, my lord, since I'm a retired government servant, my lord. At this stage, my lord, my custodial interrogations by detaining me inside the, my lord, bar may not be required, my lord. My lord.
May I please, my lord? My lord, I've produced a CD, my lord. My lord is very aware, my lord, this is a case which pertains to Prevention of Corruption Act, my lord. My lord, the gist of the case is that, my lord, 49 illegally 49 PRTs were appointed, my lord. Primary teachers, my lord. And 44 MTS, multitasking staffs, my lord. And this is a case for job scheme, my lord. If my lord remembers, earlier also there was a bail application in pertaining to another district, my lord, where my lord has heard and rejected the bail application. Now here, my lord, my lord, there is the CD, my lord. I've marked it, my lord. CD number 12, my lord. The first, I marked it, my lord. Paper marked it, my lord.
Yes, CD number 12.
Yes. This is the observation made after the scrutiny of the documents, my lord. My lord, you find, my lord, the service book are not tailing with the joining and the appointment dates, my lord. My lord, these people, they were appointed way back in 2017-18, my lord. But their service books were made. But they joined in 2021 or 22. All these years, yes, all these years, they were in service, they were appointed, their service book were made, they were drawing payments, but they were not serving. This was felicitated by the president. Appointment has been made by the director, but this was felicitated by the present.
Appointment were on 2018 only.
17 and 18. Some 17, some 18. But they joined in 2021 and 22. Joined the service. But in
payment of salaries and all, they were all getting.
Yes, the services were made. The modus operandi was that they will be appointed, the service will be made, the payments will be drawn, but they will not be given to the candidates. It will be distributed by the officials. And then that's why they were felicitated to join in the later stage. That was the modus operandi. And as per the CD, my lord, my lord, turns to CD number 12, my lord. The statement of the The next page, my lord. The next page. Series-
Next flag mark.
Yes, yes, next flag mark.
No, your flag marking page next page or next flag mark?
Next flag mark is the next
Oh, next
page.
page. Acha.
Next page. You'll find this statement, my lord. 167 statement of the present petitioner, my lord. Down below, my lord. Down below.
No, it's not here.
The CD number 12, next page. Next page. Next page. Only. Yeah. Down below, my lord. The 169 statement, my lord. You'll find that in the 169 statement, he is not cooperating with the investigation, my lord. There are certain aspects which he is not revealing. In fact, there are two candidates who are his daughter-in-laws. The present petitioner daughter-in-law, because he was the DDSC, the Deputy Director Education, my lord, of the district, my lord. And two of the candidates who were illegally appointed, two of them are his daughter-in-law, married to his sons. And my lord will find there are certain names in the CD where he has admitted that they are well acquainted with these people. And during the interrogation, he's not cooperating, and then he's not suppressing the fact that as to how this his daughter-in-laws were appointed. And as per the instruction which I've received from the SP SIC just last night, I've been informed that it's not in the CD, but then I've been informed that my lord, he has declared to be contesting the MLA in the upcoming MLA election. So it seems, my lord, and as per the instruction, my lord, this illegal appointment, maximum of these appointees who were illegally appointed, there are 102 numbers. A maximum of the candidates are from his constituency. So it seems like it was a pre-planned notion where like he wanted to contest election, so these illegal persons were appointed. That is the instruction which I have received. And in some of the cases, my lord, you will find two appointment letters, illegally two appointment letters, two joining reports, and all this. And some service books, my lord, services of certain candidates are missing, my lord. Service book of certain candidates are missing. And the present accused petitioner is unable to substantiate as to how they are missing. He being the head of the department at the point of time. My lord, I'm submitting a status report where the IO has submitted a status report of the entire case, my lord. And my lord, as my lord is well aware, my lord, it pertains to PC Act case, and since there is so much of money involved, it is an economic offense, my lord. And in such kind of case, it has to be viewed from a different perspective, my lord. My lord is aware, my lord. In fact, in some states in the state in the country, in PC Act, NCC bail are not even applicable. So, and therefore, my lord, I strongly oppose the bail application. And then, my lord, the FIR was lodged in December 20 only, 20th of December 2023. So it is in a very initial stage. And since he's not cooperating, because he knows that he has the protection of the interim order, my lord. So, and he'll not be arrested. So it hampers the entire investigation, my lord. I'll just place a small judgment, my lord. My lord is well aware of the Chidambaram judge. I'll just go to the relevant paragraphs, my lord. Para kitna tha? Para 74. Start from para 74. Para
Para?
74. Page 59, my lord. May I please? Ordinary arrest is part of the process of the investigation intended to secure several purposes. There may be circumstances in which the accused may provide information leading to the discovery of a material and relevant information. Grant of anticipatory bail may hamper the investigation. Pre-arrest bail is to strike a balance between the individual's right to personal freedom and the right to of the investigating agency to interrogate the accused as to the materials so far collected and to collect more information which may lead to recovery of relevant information. Now, 75, my lord. Ordinary arrest is a part of the process of investigation intended to secure so and so. The accused may be to be questioned in detail regarding various facts of motive, preparation, commission, and aftermath of the crime and the connection of the other persons, if any, in the crime. There may be circumstances in which the accused may provide information leading to discovery of material facts. It may be necessary to curtail his freedom in order to enable the investigation to proceed without hindrance and to protect witnesses and persons connected with the victim of the crime. To prevent his disappearance, to maintain law and order in the locality. For this or the other reasons, arrest may become an inevitable part of the process of investigation. The legality of the proposed arrest cannot be gone into an application under Section 438 of the Code. The role of the investigator is well defined and jurisdictional scope of interference by the court in the process of investigation is limited. The court ordinarily will not interfere with the investigation of a crime or with the arrest of the accused in a cognizable offense. An interim order restraining arrest, if passed while dealing with an application under Section 438 of the Code, will amount to interference in the investigation, which cannot at any rate be done under Section 438 of the Code. Now I'll just directly go to para 78, my lord, economic offense, my lord. Now, since lots of, the illegal appointments were made 112 numbers, my lord. So lots of money was involved. So in such an situation, my lord, it can be termed as an economic offense, my lord. The power. No, 78, my lord. Para 78. Powers under 438 CRPC being an extraordinary remedy has to be exercised firstly, more so in the case of economic offense. Economic offense stands as a different class as they affect the economic fabric of the society. Now, my lord may come to para 80, my lord. Observing the economic offense is committed with the deliberate design, with an eye on personal profit, regardless to the consequence to the community. In so and so, so and so, the entire community is aggrieved if the economic offender who ruins the economy of the state are not brought to book. A murder may be committed in the heat of a moment upon passion being aroused. An economic offense is committed with cool calculation and deliberate design with an eye on personal benefit or personal profit, regardless of the consequences to the community. A disregard for the interest of the community can be manifested only by the cost of forfeiting the truth and faith of the community in the system to administer justice in an even-handed manner without fear of criticism from the quarters which view white-collar crime with a permissive eye, unmindful of the damage done to the national economy and the national interest. Now, 81, my lord, down below. Economic offense constitute a class apart and need to be visited with a different approach in the matters of bail. The economic offense having deep-rooted conspiracies and involving huge loss of public funds needs to be viewed seriously and considered as a grave offense affecting the economy of the country as a whole and thereby posing serious threat to the financial health of the country. While granting bail, the court has to keep in mind the nature of the acquisition, the nature of the evidence in support thereof, the severity of the punishment which conviction will entail, the character of the accused, circumstances which are peculiar to the accused, reasonable possibility of securing the presence of the accused at the trial, reasonable apprehension of the witness being tempered with the larger interest of the public, state, and other similar other considerations. Now, para 82, my lord. Referring to so-and-so in so-and-so, while hearing an appeal by the enforcement director against the order of the single bench of the Bombay High Court granting anticipatory bail to the respondent thereon, the Supreme Court set aside the order of the single bench granting anticipatory bail. Granting anticipatory bail at the stage of investigation may frustrate the investigating agency in interrogating the accused and in collecting the useful information and also the material which might have been concealed. Success in such interrogation would elude if the accused knows that he is protected by the order of the court. Grant of anticipatory bail, particularly in economic offense, would definitely hamper the effective investigation, having regard to the material said to have been collected by the respondent, enforcement director, and considering the stage of investigation, we are of the view that it is not a fit case to grant anticipatory bail. Now, my lord is well aware. This is an illegal appointment of PRTs, my lord. The teachers, my lord. And PRTs are primary teachers, my lord. They are supposed to train the young brains, my lord. And these young brains are the backbones of the country, my lord. Now, if they are illegally appointed, what would be the consequences, my lord? It would not only affect the state, my lord, but it will affect the entire country, my lord. We are not talking about the economic offense. We are talking about the effect which it will have on the society, my lord.
May I response to the submission made by the council for if it is completed, my lord.
Therefore, my lord, since my lord has produced a CD, my lord, and the present accused petitioner, he is unable to explain as to how the doctor-in-laws were appointed and as to how six PRTs and I think 9 MTS service books are missing, meaning they have been concealed. And there is an apprehension that, my lord, if he's on bail, my lord, some other documents may be concealed. So therefore, my lord, and this being a very serious offense, my lord, I vehemently pray that, my lord, the bail may be rejected, my lord.
Yes, Miss Madam. My lord, I'm truly appreciate the submission made by the learned PP. My lord, is because by submissions, my lord, the investigation, my lord, by CD, my lord, it is revealed that my lord may kindly appreciate that the investigation part, 90% of the investigation is done, my lord. 90%, my lord. By that revelation, my lord. There's nothing to give, my lord, any further, my lord, the informations further interrogations of the this applicant accused persons, my lord. Entire thing has been, my lord, under the notice and brought to the notice of the, my lord, the investigation authority as well as the police, my lord. My lord, more interestingly, my lord, if service book is missing, my lord, it is prior to, my lord, my joining, my lord. My lord, may kindly peruse the statement, amendment made in my petition, my lord, page number 5, paragraph 5, my lord, wherein I have specifically made. Just for a moment, my lord, may I take your lordships to the fifth line, sixth line of the paragraph, my lord. My lord, petitioner joined at as DDSC from in the year 2019, my lord, July 2019 till his superannuation in the on 29 April 2023, my lord. Now, my lord, interestingly, my lord, he's making submissions on the appointment was made in the year 2017-18, my lord. For a moment, my lord, may I take your lordships to the appointment order which I have enclosed also, my lord. Page number, my lord, 24, annexure 2, my lord. This is prior to my joining, my lord. Page number 24, my lord. Page number 24, annexure 2 series, my lord. My lord, appointment order is dated 13 November 2017, my lord. Whereas I joined as a DDSC only in the year 2019, my lord, after 2 years. And my lord, interestingly, my lord, appointment order, my lord, this is the one of the appointment order in respect of one PRT, my lord. Name is given, my lord, PRT, Mubom Bodung, my lord, appointees, my lord, appointed by the, my lord, just below, my lord, who has given this appointment, my lord? Director of Elementary Education, my lord. My lord, Director of Elementary Education, Government of Arunachal Pradesh, Itanagar, my lord. My lord, I don't have any, my lord, the role in the event of any appointment order is made by the higher authorities or whosoever may be, my lord. It is interestingly, my lord, prior to my joining, my lord. And one appointment, my lord, another appointment of 2000, my lord, PRT, MTS, my lord, multitask services, my lord. Page number 27, my lord. Page number 17, in respect of one MTS, my lord. It is in the year 2018, my lord. Specific date is 13 April 2018, my lord. This is also prior to my joining, my lord. My lord, I don't have any role. My lord, my name has been, my lord, implicated. My lord, he has rightly pointed out my political rivalry, who is sitting MLA. He is insisting then the present applicant, my lord, is fairly disclosed by the, my lord, the PP. That only by virtue of this, I am, my lord, I am the one of the my lord, the contesting candidate, going to be a candidate, contesting candidate. My lord, having knowing all these facts, my lord, the sitting MLA is insisting upon my lord, the IO of the case and the investigation department to, my lord, implicate the present application in this present proceeding. Time and again, my lord, he is approaching, my lord, he insisting, my lord, rightly pointed out because of this political interference, my lord. He has pointed out, my lord. We are not specifying anything in our, my lord, the application, but from the statements, my lord, from the submissions made by the, my lord, the investigation authority is very much, my lord, clear. Now it is often clear, my lord, that only because of that, my lord, political rivalry, my lord, I have been implicated in the present case, my lord. And my lord, termination order, my lord. Annexure 3, page number 30, my lord. And this termination order has been, my lord, in from the year, my lord, it is very much clear the my lord, the appointees who were terminated from the service, my lord, column number 3, my lord. I'm sorry, my lord, type copy is at page number 34. My lord, how many persons has been illegally appointed is not concern of this applicant, my lord. Column number, my lord, order of appointment, my lord. all 2016, my lord. Page number 34, 16, my lord, education, my lord, numbers ED 2, EED 2, 681, PRT 2016, my lord. All are from 2016. 16, all are, my lord, prior to my joining, my lord. If service book is missing, my lord, I don't have any, my lord, control over on it. And my lord, why my lord, this accused person applicant has been, my lord, targeted, my lord, he has already disclosed. My lord, why don't they, my lord, searching the persons who were serving as a, my lord, deputy director prior to my joining, my lord? Where is the, my lord, the questions for the question, my lord, the lawful impediment on the part of the investigation authority to inquire the persons who were there in the office prior to my joining, my lord? They are only targeting me only because of, my lord, I'm the one of the expected candidates
As
for,
per you, when you have joined?
my lord, in the month of July 2019 only, my lord. 2019, man, is the DSA and superannuation in the month of April 2023, man. So therefore, my lord, I don't have any nothing, my lord. Now, the interestingly, my lord, is my lord, may kindly produce my additional affidavit, my lord. My lord, I was called for, my lord, the statement, recording of the statement by the, my lord, IO of the case on 3 occasions, my lord. Since 10:30 to 4 p.m., my lord, I was there, my lord. I was detained. Annexure 2, my lord. Sorry, Annexure 1, page number, my lord, 6, my lord. This is the applications, my lord. And I appear before the IO of the case for giving my statement, entire details, my lord. As I have already pointed out, my lord, my entire things has been recorded. Even my lord, service, my lord, the Aadhaar card, driving license, my lord, bank details account, my lord, my family members, my lord, names, details of my family members. Everything has been disclosed, my lord. So therefore, my lord, my custodial, my lord, I'm at the age of 61 years, my lord. And now, my lord, retired service government job, from the government job, my lord. At this stage, my lord, the further detentions of the accused persons will, my lord, the application will cause a serious lawful, my lord, the prejudice to the accused person applicant, my lord. Now, my lord, apart from that, my lord, my lord, rightly pointed out, this is the economic offense, my lord. We are not, my lord, disputing on that aspect, my lord. If economic offense is, my lord, the committed, my lord, if any, my lord, the things has been done, my lord, it has been done by the, my lord, other officers. I don't have any connections in the present case, my lord. It is prior to my joining. Appointment order has been also made by the, my lord, the higher authorities, man. So therefore, my lord, by appointment, my lord, my lord, by affidavit, my offense is not disclosed, my lord. So therefore, my lord, I'll sorry to bother your lordships to read against the FIR, my lord. Why I deliberately, my lord, left as because by this affidavit, my lord, there is no, my lord, disclosures of any offense committed by me, my lord. Therefore, my lord, may I read again, my lord, FIR, my lord. My lord, with intense belief and assure hope, while inviting your attentions to the subject cited above, my lord, I'm reading the FIR, copy of the FIR, my lord, page number 18, my lord. Cited above, I am to inform you then that on the 21/11/2023, my lord, I had filed an RTI before Deputy Director of School Education bowling for furnishings of related documents in regards to appointment of 49 PRTs and 44 MTS under Department of Education of Siang District. In the meantime, concerned Deputy Commissioners of the School Education has directed her junior staff, namely Sri Nong Parong, UDC, DDSC office bowlings to furnish the sought documents. But my sought documents are not yet furnished till today, and the matter is pending before the Honorable Court of State Chief Information Commissioner Itanagar, Arunachal Pradesh. It is a fact that Sri Nong Paran has conceals the documents and reluctant to furnish me the same. Still, there are many numbers of the staffs in the Department of the Education, Siang districts who were illegally appointed during the year 2018 to 2020. The most of the PRTs and MTS appointed in the year 2018 to 2023 has not yet performing their duties and has no proper specific proper and specific post places. However, the entire episode has been revealed by the terminations of the 102 staffs education department under Siang district. Further, it is also pertinent to inform you that the Sri Nong Paron may direct or indirectly indulge in massive illegal appointments of the 102 staffs in education department of Siang district who were recently terminated by the government of Arunachal Pradesh on dated 23rd 11/2023. There is gross illegal appointment all over the state in each and every department that deprive the rights of the fair competitions to thousands of the well-educated and well-qualified unemployed youth across the state. The same is contravenes of right to equality and enshrined under Article 14 of the Constitution of India. Hence, such demoralizing the tactics as trends to appointment pertaining to the government job needs to be doing away at earliest in the interest of unemployed youth of the state. A qualified unemployed youth who is toiling day and night to find a decent job. I'll skip this portion, man. Nowhere disclose any offense committed by me, man. Admittedly, RTI application was filed. RTI application was filed. And that RTI application was, the information to that applications was not
FIR, the appointments were on from 2019 to
Correct, ma'am.
2022. How? As per the FIR, the allegation, all the appointments were 2019 to 2022.
My lord.
No.
No, where it is.
FIR.
FIR, yes, FIR 2019 to appointment order during the year 2018 to 2020, This is wrong, Termination order he has enclosed. Lordship has already seen it is all the appointment order was made in the year 2016, my lord.
17.
Say it is not 2020 or 23.
What do you want to say, Mr. Opada,
My lord.
regarding the appointment order, the annexed 3?
Yes, ma'am.
Here, the appointment order seems to be passed on, dated all are in 2016.
Yes.
And appointment, date of appointment were 17, 18.
Yes, my lord.
18, even almost 18. But
Yes.
as per him,
But-
was not in a.
But it is very correct, my lord. It was not in his time. That I admit, my lord. But then, if my lord comes to his application, my lord, page 24, my lord.
24.
Yes, ma'am. The appointment order that he has annexed, madam.
This is of course 2017, my lord.
He was appointed in 2017. And the probation period was for 2 years, my lord. But he joins in 2021. How was it possible, my lord? That's what I'm saying. ma'am.
As per him, he joined in that.
19. He joined in 19. He joined in 19.
But he was under deputation.
My
No,
lord.
he was under deputation.
No, my lord. He joined. I'm not talking about
Appointees were the petition.
the candidates, my lord. This is the appointment order. He says it was not appointed at his time. I admit he was not appointed when he was the DDSC. He was appointed in 2016-17. But he joined in 2019. But the appointment order itself says, my lord, the probation is for 2 years. But when he joined in 2019, he knew that time has already lapsed. But why did he facilitate to let them join after that has been lapsed? And he never inform the deputy commissioner. He did not never inform the director about these lapses. That is in the city, my lord. It is reflected in the CD. All these anomalies have been reflected, my lord. My lord, can you see? So and so, para 2, page 24, my lord. The appointment is made against the vacant post of so and so promoted. The appointment shall be promotion period for 2 years with effect from so and so, so and so. Now, if he is appointed in these candidates in 2017, he joins in 2019, but he let them join in 2021 or 22. How could that be possible, my lord? Therefore, it is a very suspicious combination, my lord. There has to be some nexus, my lord. And he, as a DDSC, has a duty, my lord, to inform the anomalies which occurs in his district to the director, my lord. That has never done, my lord. He felicitated, my lord. He abused his position, my lord. And there was a reason for doing that, my lord. That is what I have explained, my lord. What was the reason? What was the modus operandi, my lord? That was the reason, my lord. I'm not saying that, my lord, he has appointed them. They were appointed but he has a connivance with them. Why his interrogation is necessary? If my lord sees the 161 step and he's not cooperating because he's protected by the interim order, he says, I will not comment. And he doesn't comment upon the missing service books. He does not say no comments on the appointment of his daughters. Why? Because he knows that he is protected. That's why, my lord.
My lord, in that connections, my lord, my lord, specific direction may be given to the my lord, the applicants, present applicant, to my lord, give detailed information on that part, my lord. My lord, the rest is not disputed, my lord. That part is, my lord, is required to be, even if it is required to be investigated, my lord, I'm ready to cooperate with, my lord. I'm not running anywhere, my lord. But I am ready to cooperate as because, my lord, on the 3 occasions, my lord, I have given my statement that has been recorded, my lord. My lord, if the statement my lord, statement of the accused persons is recorded, my lord, therefore, my lord, my only my lord, humble submission before lordship is the custodial interrogations is not required at this stage, my lord. And the economic offense is committed by the my lord, other accused person. They are not the one concerned about the my lord, this person accused person. Now, my lord, one aspect, my lord, if my lord, accused persons were facilitated for appointment, my lord, allowing these illegal appointees to join in the year 2023 during my tenure, my lord. It was, my lord, only because of the directions given by the higher authorities, my lord. The appointees, my lord.
But that is not reflected, my lord.
My lord.
Therefore, my lord,
that investigation,
there is a larger connection, my lord, and we need to find out that thing, my lord, which
so therefore, my lord,
it's not been done.
Since I have given my statement, my lord, I have recorded my statement, my lord. To that extent, my lord, I may be allowed to, my lord, give a statement to detail in that, my lord, the aspect, my lord. And my lord, I'm ready to cooperate with the investigations, my lord. I'm, my lord, 61 years, my lord, at this stage, my lord, and my lord, rightly pointed out, my lord, if such is the positions, my lord, every fortnight, my lord, I'm ready to appear before the IO of the case, my lord. And so therefore, my lord, there is a, my lord, I have some authority if lordship is relying upon the, my lord, the authorities on the, my lord, regarding the bail. My lord, I'll give in writings, my lord, for
You can
my
please
lord,
submit.
my lord.
Please. I
Yes.
pass the order.
My lord.
And my lord,
Item number 11, my lord.
Item number.
11, my lord.
Item number 11 also you are there.
Yes,
Yes. And my lord, no, same. He's from the same case, my lord. He's the UDC, my lord. Upper division.
my lord,
clerk.
lowest grade serving in the department have been, my lord, lordship has already seen in the FIR, my lord, that it is me whom, my lord, the direction has been given for furnishing of the, my lord, some information is sought for, my lord. They are politically nexus with, my lord, they knowing the facts of the case, my lord, this, my lord,
11.
item number.
Item 11.
I'm serving UDC, my lord. Presently, I'm serving UDC, my lord. My lord, I have nothing to do with all the, my lord, the allegations, my lord. I'm UDC, my lord. I am serving under the DDC. I am serving under the government, my lord, the higher authorities. I'm serving as a government, my lord, employee. applicant is non-parent, my lord. Serving as UDC in that establishment, my lord. And my involvement, my lordship has already seen in the FIR only for the non-furnishing of the information, my lord. The information, if it is not furnished, my lord, admittedly they have also mentions in the FIR that my lord, against the non-furnishing of the informations by the DDSC office, my lord, they filed appeal before the Chief Information Commissioner. And my lord, only for the non-furnishing of the some information is sought for. My lord, why this FIR has been dragged against me, my lord? That is my question myself to questions to myself, my lord. My lord, the work of the UDC is very limited, my lord. I am serving under the subordinate, my lord. So therefore, my lord, and my lord, I have filed the additional affidavit, my lord. And in additional affidavit, my lord, on after my lord, the direction of this honorable court in that interim order, my lord, I appear before the my lord, IO of the case on 3 occasions, my lord. Paragraph, my lord, 2. Paragraph 3, my lord. On my lord, 9 January, I appeared before the IO of the case. And whole day I was there, my lord, till from 10:30 to till 4 p.m. And on again, my lord, 12 January and 12 January, my lord, I've given my entire details, my lord. Bank statement, my lord, my family members, my lord, all other things, my lord. I've deposited, my lord. So therefore, my
So
lord,
you want
and
to say that your only allegation brought against you is that you have not supplied the information
My-
which was sought for under the RTI.
my lord. So therefore, my lord, considering the special aspect, my lord, that I'm only serving as a UDC in the department, my lord, that establishment, my lord. I have been personally dragged, my lord. And my name has been specifically mentioned in the FIR, my lord, but nowhere, my lord, disclose the FIR, my lord. My lord, may kindly peruse the FIR, my lord, while my lord considering the my lord. There is no disclosure of any offense committed by me, my lord. Like my lord, investigation aspect, my lord, that I'm ready to cooperate. My lord, I'll not run anyway, my lord, since I'm the locality of this state, my lord, and I've given my details also, my lord. And my lord, interestingly, my lord, this accused persons was the statement of this accused persons was recorded, my lord, by the IO of the case, even before filing of this FIR, my lord, the anticipatory bail, my lord, this application. My lord. On 2 occasions, my lord, my statements was recorded by the IO of the case at my present place of posting, my lord. On 2 occasions, my lord. Thereafter, my lord, the apprehendings erased, my lord. Subsequently, this application has been filed by them, my lord, present applicant. So therefore, my lord, I'm ready to cooperate with the IO of the case anytime and anywhere, my lord. So therefore, my lord, at this stage, my lord, considering the entire aspects, my lord, my lord, the interim bail may be, my lord, made absolutely.
My lord,
Separate CD is there.
no, same CD, my lord. We have taken his statement, my lord. My lord, he is the UDC, my lord, upper division class, under the same establishment, my lord. And he is the custodian of the service books and the documents. He is the one who prepares it, my lord. And he is, we have taken his statement, but then as per the instruction and as per the CD, my lord, he is not cooperating. And he is unable to explain as to how the service books are missing. And in fact, in the CD, my lord will find that his elder brother and his sister-in-law has also been illegally appointed. His elder brother, his sister-in-law. And my lord, in the 116 statement, he has admitted that he's well acquainted with so many of the illegally appointed persons, my lord. Yes.
He had a contact.
No, yes, he was already in acquaintance with so many illegal appointments, my lord. And it's the fact that he was the one who was preparing the service book and the pay slips and all. He was preparing the service book. He was the one who was the custodian of the service books, preparing the pay slips. During the course of interrogation, he is not cooperating as to why, because he's unable to substantiate as to how his brother and because there was no any examination. Sister-in-law was appointed, and as to how the service books are missing. And my lord, since he was involved in the entire scheme of the case, my lord, and we apprehended, my lord, there is a larger, I mean, uh, syndicate. Now we have only bail for 2 persons we filed, but then we had an apprehension there is a larger syndicate, and that has to be cracked down, my lord. And they being the custodian of the documents and the service books, my lord. Their custodial interrogation is necessary. They are not cooperating as to why, because they are protected by the interim order. And it is in a very initial stage of the investigation, my lord. Therefore, my lord, may I humbly pray, my lord, in both these cases, my lord, the bail may be rejected, my lord.
My lord, respectfully, my submission is, my respectful submission is, my lord, it is, my lord, wrong on the part of the, my lord, the investigation authority that I am not cooperating, my lord. I am cooperating from the day one, my lord, when the FIR was registered, when I am appearing before the case, my lord, the IO of the case, my lord. And my lord, interestingly, my lord, as I have my lord, as I have pointed out, and as I have submitted, my lord.
That is a
My lord,
status report which has been filed by the IO, my lord.
My lord,
The gist of the case has been given, my lord, as to
my
how.
lord, investigation in that entire aspect has been completed, my lord. If anything is required to be done, my lord, if the further investigation is required, my lord, I am ready to appear, my lord. Entire thing has been disclosed, my lord. There is nothing left, my lord. And even if illegal appointment is made, my lord, if there is a syndicate, if there is only, my lord, the facility, I am by virtue of the, my lord, UDC, my lord, it is my bounden duty as a government job, my lord, I have to, my lord, give services to the, my lord, the authorities, my lord. So therefore, my lord, the entire investigation, my lord, may kindly appreciate the one things, my lord, from this revelation of the facts, my lord, from this CD, my lord, it is clear in one thing, that investigation in respect of this, both the accused person is almost completed, my lord. If anything is required to be done, my lord, I am ready to furnish, my lord, every day I am ready to appear before the IO of the case, my lord. Even I am ready to, my lord, give my entire, my lord, the things before the IO of the case, my lord. What remains, my lord, there to be investigated further, my lord. There is nothing, my lord. 90%, my lord, the entire things, my lord, CD has disclosed, my lord, everything, even political interference, even, my lord, my lord, apprehendings that I'll be contesting candidate in that particular constituency. That is also reflected in the CD, and he has already pointed out, my lord. Only because of that reasons, my lord, I am implicated, my lord. And this person, the my lord, second bail applicant is, my lord, is serving in the department, my lord, maybe because of non-publishing of the certain information, my lord, that FIR has been lodged against me. So therefore, by disclosing of the, my lord, the material facts, it is clearly constituted there, my lord, investigation in respect of this both the accused person is almost completed to the extent of 90%, madam. And if certain things is required to be investigated, as I have already pointed out, I'm ready to cooperate. I'm ready to appear before any whatever terms and conditions before the lordship is incorporated. I'm ready to appear, I'm well settled family. I have well settled family. I'm closely deeply rooted with the society. I don't have any adverse record in entire my service life. Only because of this political interference, I have been implicated. Deeply available.
My lord, I have filed a status report, my lord.
Yes, this is the status.
Yes, my lord, Makali Perus with my lord. My lord, para 5 is very important. Just for a second, my lord. Para 5, my lord. He being the custodian of the service books, my lord will find that certain service books are missing. Now he is not explaining, my lord. Appearing in the before the IO is irrelevant. Yeah. He says that he'll appear. He has appeared 3 times, but he is not substantiating that why these service books are missing. That's why we are in the we need to know why they are missing. If he can do it now, if he's that's why we are saying that he's not cooperating. He has already tampered with the evidences, my lord. There is a case, my lord. Not only 10, my lord. There are other service books which. So there is an apprehension, my lord. In future also that might happen, my lord. How could those service books? It's a very serious issue, my lord. Oblige, my lord.
On leniency, my lordship may kindly consider these aspects, my lord. My lord, I'm if my lord require, my lord, I'll put it. My lord.
On any authority you have?
My lord.
Will there be a lengthy order? That's what I'm passing in the.
My lord. Deeply obliged, ma'am.
My lord, the citations, whether my lord will require the paragraphs on that. If the citation which I have
Yes,
given, oblige, my lord.
May, my lord.
Yes.
Yes, my lord. This is subsequent bail application.
Suspended?
Subsequent bail application, my lord.
Okay.
Yes, my earlier one was rejected by the special judge, NDPS, my lord. This case pertains to NDPS, my lord.
Case pertains to under which section it is? Huh?
My lord.
NDPS?
My lord, NDPS Act, my lord. My lord, FIR is, my lord, page number 11 to 13, my lord, FIR.
Why is that page number?
11.
11.
Yes, type copy is page number 12. Page number 12. May I read, my lord?
Commercial quantity?
No, my lord, it's intermediate quantity. May I read, my lord? With due respect, I have to inform you that on dated 12/12/23, it's so hours, I got informations from reliable source that one Mrs. So-and-so was selling drugs in CK Colony, Itanagar. Immediately, I informed the matter to the officer in charge, Itanagar Police Station, in writing. After that, I formed a team comprising of myself, SI so-and-so, Lady Constable so-and-so, Lady Constable so-and-so, and Constable so-and-so, and proceeded to CK Colony for search and seizure. At CK Colony, the house of the suspect was identified with the help of the locals and two ladies, namely so-and-so and so-and-so. They voluntarily agreed to witness police actions as requested. Then the house of the suspect so-and-so was visited. So-and-so was allowed police to search her room. Upon search of her bedroom, one plastic pouch containing 6.10 gram of suspected heroin and 24 plastic vials containing 2.92 gram of suspected heroin, excluding weight of the vials, were recovered. The above mentioned drugs were sealed in presence of the indefinite witnesses, my lord. So, my lord, pursuant to this very FIR,
Since when he is in custody?
since 13/12/23, my lord. It's been 41 days, my lord. 43 days, 43 days, my lord. And my lord, offense involved is 21B of the NDPS Act, my lord. That is, my lord, intermediate quantity, punishable up to for a term which may extend.
Robert, you admit that those contraband when recovered from your house. This is admitted, right?
Well, that is,
You admit this one.
well, that part is, my lord.
Admitted.
Admitted. My lord, since this is 21B, and if this offense is pertaining to 21B, my lord. So here, my lord, punishable, the offense is punishable up to for a term which may extend to 10 years, my lord. So, my lord, in this case, my lord, rigors of section 37 will not attach, my lord. So, my lord, and my lord, moreover, my lord, as far as 167(2) of CRPC, my lord, the maximum detention period is 60 days, my lord, in such a case, my lord. So, my lord, it's already been 43 days, my lord. So, next 13, it will be 60 days, my lord. And now I am in custody, and my lord, one of the ground for filing this bail application is, my lord, one of my minor son, my lord, who is age about 4 years, my lord, that I have annexed number 3, my lord, that is page 16, my lord. He is having an ailment, my lord, like chest pain, vomiting. So, my lord, I being a mother, and I am the best person to take care of my ailing son, who is just 4 years old, my lord. So, my lord, considering all these facts, my lord, and moreover, I am a woman, my lord. So, my lord, I am in urgent bail, my lord.
Sorry to say nowadays women are too engaged in this.
My lord?
Particularly the women are being engaging in this profession of trafficking drugs. She may be a woman.
My lord. However, my lord,
Every state, in Assam also,
my lord,
Manipur,
yes, my lord.
the women are the thinking. Anyway.
I have the CD, my lord. I'll just refer to 2-3 paragraphs on this. In this case, my lord, FIR was lodged on 12/12/2023. And during the course of investigation, my lord, altogether 9.2 grams of suspected heroin was recovered from the residence of the present applicant accused.
6.2 or 9.2?
9.2, my lord. 9.2. I take, my lord, to page number 33, my lord. 33 and 34 are the seizure memo. 9.2 grams of heroin. But subsequently, my lord, the accused was arrested on 13/12/2023 at 12:30 hours, which is in page number 38. It's the arrest memo. That's the inventory, that's the arrest memo. And on the same day, my lord, inventory was prepared in the presence of Judicial Magistrate First Class in compliance of Section 52A. And accordingly, my lord, further the same has been sent for FSL for the expert's opinion, which is in page number 57. '57 is the inventory report which has been prepared, certificate. And the FSL is in page number 21, which has been sent to the FSL for expert opinion. Page
Is
number.
there any report of the FSL also?
Not yet received.
Not yet.
Not yet received. Only the forwarding, my lord. Page number 21. And as of now, my lord, altogether in this case, 4 prosecution witnesses has been examined. If I may take, my lord, to page number 58 to 61.
If I may take straight away to page number 61, this is the statement of the accused. On being examined, I would like to state that I have procured my drugs from Bandadeva. Recently, I bought only one packet. I had not opened the packet yet since last week. I know the person selling drugs, a lady, as I often visit Bangla Mara. I work alone. This is my first instance of arrest. I usually sell local ornaments. Previously, I had a pan shop at Akashdeep. I have 32 rooms in my rent. Lots of non-travels have taken rooms, so they have my number. They would often call me and tell about drug dealing. Kaliama and Norulma are the suppliers supplying drugs to me. I have only their number. However, I don't have the number of the main supplier. They used to live in my rent, but they had left a long time ago. They contact me over the phone saying, "Madam, do this and that in this regard to drug dealing." This is my second consignment only. So far, the investigation part is concerned, my lord, this is an admitted position and the 67 has been recorded. And so far, if we compute the length of detention as of today is 43 days. And so far, the status of the case is concerned, my lord, it's in the third page. The objection which has been raised by the investigating authority. Those are the objections which has been raised by the investigating authority.
That apart, most probably the FSL report is not it.
What do you have to say?
Today is 43 days.
43.
If again for another 14 days, in the meantime, most probably
Yes.
FSL report may also come.
In that case, my lord, we can fix this matter after a few days, and then in the meantime, updated case diary can be. Madam.
For that reason, your CD is up to date, was an up to date CD?
Yes, madam.
My lord, otherwise I'm behind Bahar for 43 days, my lord. And my lord,
See,
that
you are the.
one of the ground, my lord, is,
admitted fact that you are the.
yes, my lord, that I will not dispute, my lord.
Can help you. It is item number 10.
Yes.
Third, Mr.
El Kurdu. El Kurdu.
It is an application of section so and so in connection with so and so. From the, it is submitted by the learned counsel for the petition that she is behind the bars since 13th of 13/12/2023, and hence considering her length of detention and also considering the fact that her minor son is suffering from some health issues, she may be released on bail. However,
Yes, ma'am. Yes, ma'am. And in the meantime, updated case diary.
Of this month, madam.
31 will you're not serving your purpose. We are going to help you only. 7 or 8 February will do, I think, no?
7th.
7th of so and so, and post of CDB return. Call for the up-to-date question. 7. Because 31st may not help.
Yes.
That's why we're giving you on 7 or 8. So that by that time, most probably FSL report will also receive by the court. Then it can be.
Obliged, madam. Obliged.
May I please your lordship? Lordship, item number 12, 13 and 14 are analogous matter arising out of same FIR. Lordship.
12, 13, 14.
Lordship. Lordship, interim bail was granted on 10 January 2024, Lordship. Lordship, I am cooperating, Lordship. As per the direction of this honorable court to hand over the Alipen.
Hand over the
Alipen, Lordship, which was
Bill?
alleged to have been stolen, Lordship. That has been handed over, Lordship.
What's the stolen article?
Lordship, elephant,
Oh,
Joy
elephant.
Morty. Elephant,
You
elephant.
stole the elephant.
Lordship, that is the allegations, Lordship.
Okay.
That is the FIR is at page 13, Lordship. Type copy of the FIR. Original FIR is at page 12, Lordship. Photocopy of the This FIR was lodged on.
Nowadays, to keep it, to keep a elephant in a house or somewhere, you need a lot of expenditure for an elephant.
Lordship, exactly.
So
Lordship.
it will be not
Lordship,
proper
exactly.
for anyone to keep an elephant nowadays.
Lordship, it's almost impossible, Lordship. There was a bit of miscommunication between the mouth of the elephant and these people who are alleged to have involved. In fact, in the FIR, they are not named, Lordship. Just 7 persons are involved. It is just.
She was a female.
She was a female. In fact, she was
Joy
pregnant. Pregnant, Lordship.
Oh, pregnant was
Lordship.
So you handed over the elephant now.
Lordship,
That
to the
was
own.
which in your position only.
Lordship, in fact, it was in our possession, Lordship. That elephant was in fact taken by us, but since the mouth of the elephant has misrepresented us, saying that he is the owner of the elephant, Lordship. I have categorically mentioned that statement in my.
Have you paid anything to Mahmood?
No, Lordship. He handed over to us to sell the elephant, in fact, to some other third party, Lordship. So we took that elephant in our custody and we wanted to sell it. But later, after he was arrested, we came to know that he is not the owner. Owner was some other person. So we contacted that owner also, and then we have handed over.
Three are there. You are the same family member.
No,
You
Lordship.
belong to same family, or no?
No, Lordship.
But the allegation against you three are same.
Same, Lordship. In the FIR, they have simply mentioned that same mouth along with 7 other people, Lordship. This is the elephant, Lordship, that was handed over, and on the back side, Lordship, it is written, in fact, it is written in Assamese, Lordship, that just the undertaking of receiving the elephant back by the owner, Lordship. And my instruction is that, Lordship, on 4 occasions, Lordship, I have appeared before the IO on 12, 13, 15, and 20, Lordship. But then IO has some or other reasons, Lordship. He has shown some urgent work, and he failed to record our statement, Lordship.
So at present, your statement is not here, Mr. Kalu. You said he is not there. His statement is not available. Their statement is not available.
Not
in
yet
the record.
recorded.
Recorded.
Yes, and it speaks for some suitable date because IO concern was on leave for 12 year on leave, and an investigation was on hold. So and moreover, this name accused was arrested, and name accused yes, he disclosed that there were 7 peoples who approached him to assist to catch the elephant, who approached him to help to catch the elephant, and he was paid 5,000 rupees also. And later on, when he disclosed the name, they approached this court for anticipatory bail. And of course, they have appeared before the IO, but IO, due to some preoccupied occupation in duty, could not record their statement. And the 164 statement, this arrested accused is ready to give 164 statement, and it is fixed for 29th of this month. So matter may be deeper because they are only under interim protections. Matter may be deeper till so that 164 will be recorded as well as the statement of these applicants will be
Okay, as per you, the statements of these applicants are not yet recorded.
not yet recorded.
yet.
Because
On 4 occasions I have appeared with.
I was on leave, on year leave for 12 days. Matter may be deeper.
Same order will be there for 12.
13 and 14. JG, Lordship.
Yes.
He's my colleague, Lordship. I am JG.
Sorry. Heard Mr. J. Gini, the learned counsel for the petition, and also heard Mr. G. Tali, the learned petition people, appearing on behalf of state respondent. CD receipt. This is an application in section so and so, CD receipt, where is the it is submitted by the learned counsel for the petitioner that after obtaining the interim pre-arrest bail, he appeared before the IO on 4 occasions.
4 occasions.
4
12,
occasions
13,
to
15 and
record
20.
their
Lordship.
statement, but due to the IO could not. But was it IO, as per you, IO was available that time or no?
Lordship, he was available, but he showed some difficulties to
But IO
record our
was not
statement.
in a position to record the statement of the petitioner. However, as per direction of the direction of this court, he along with others have already handed over the elephant to the owner and ready to cooperate the IO in further investigation of this case. Next point, in this context, the learned judicial PP has submitted that the IO, it is a fact that the petitioner appeared before the IO, but his statement could not be recorded as the IO was on leave and due to some personal engagement. And further, it is submitted that the FIR name accused, that is the Mahmoud of the elephant, is also ready to give his statement under section 164 CRPC, and which has been fixed on
29th of this month.
29th of December
January.
29th of January 2024. Accordingly, the learned additional people has submitted that by that time the IO will also be able to record the statement of the petitioner as well as the statement of the other accused under section 164 CRPC. Stop considering the submission made by the learned counsel for the petitioner as well as the additional people. Let the CD be returned, calling for the up-to-date case diary with the statement of the petitioner, and matter be fixed on as per you 29, then matter.
8 February.
8 of February.
Yes.
8 of February 2023. Until then, the petitioner will be allowed to remain on interim pre-arrest bail till the state of the state.
One for a small submission regarding the handing over of the elephant.
Since
It will not mitigate the offense of theft. Handing over will not or not dilute.
Lordship, handed over. Since there is a direction from this honorable court in the last occasion when interim order was passed.
Yes, as per the direction of the court, we have already handed over the
Lordship, can it be recorded, Lordship?
Yes,
without-
recorded.
Recorded. All right.
You give me the picture with the elephant.
Lordship.
I'm fond of animals. That's why.
Obliged.
Oblige,
So
Your Worship.
will be, your hearing will be extended up to next week, next date, and this up to date case diary will be got.
Oblige.
No, I have a submission, sorry, it's not in the submission. I have a meeting actually by 3:30. I have to prepare some notes and all also. So next up,
There is an interim order also, suspension of the interim order.
have we taken steps or?
Yes, yes, my lord, we have taken the steps. On 10th, the next day itself, we have taken to the registered AD.
So services still awaiting for 1 to 21.
Yes, my lord, all the respondents.
16, you took, as per the office note,
Yes, my
I
lord.
mean, you took steps only on 16/11/2023. So already, say 2 months
2 months. my
lapsed.
lord. Yes.
You want to get some fresh notice, or let us wait for next date?
At least for two weeks we'll wait, my lord. Thereafter, we'll take the fresh steps. In the meantime, my lord, till next week, next date, the interim may be continued.
You are Mr.
S. Chetri.
S.
S. Chetri.
S. Chetri. Heard Mr. S. Chetri, the learned counsel for the appellant from office note dated 24/01/2024. It reveals that the service is still awaiting for respondent number 1 to 21. Let service be awaited till next date of listing and next date, and till the next date of listing, the interim be continued. Interim be continued till next date of listing. List after 2 weeks?
2 weeks, madam.
3 weeks will do, I think. 2 weeks will not, at least after 3 weeks.
3 weeks.
As to be date 2 fixed by the registry.
Obliged.
Madam,
Yes.
service report upon respondent number 1 to 10 is still awaiting.
Respondent number 1
to 10.
1 to 10.
Yes.
When order is stayed already. Yes. Same order. By Mr. So-and-so, the office note dated 24/1/2024. It reveals services still awaiting for respondent number 1 to 10. Awaited next date of list after 3 weeks until next date of listing in 20. I just want to ask you one thing. It is a hearing matter, no?
Yes, ma'am.
2020.
Well, basically, my lord,
just I have a meeting that time I told you. So if it is can be completed within 1 hour, I'm ready to hear.
well, basically, my lord, they have filed an affidavit admitting our contention. So in terms of that affidavit, repetition may be disposed of.
My lord. So sorry to say, my lord, in this case, my lord, earlier it was case was handled by the Jammu, my colleagues, my lord. Now I've been entrusted to look after this matter, my lord. Now I have not received any records till now. I could not obtain any relevant document till now, madam. So in this
Relevant
regard,
document from whom you are to receive?
from previous council, my lord. T Jamo, my lord. Tagum Jamo.
Acha. And government side is also there.
And also I require to verify the affidavit, whether it was filed by the government or whether it was at directorate level.
That
My
we
lord,
don't know. That we don't know.
that is why, my lord, that is why the proper instructions required and documents. So
Every
in that
time
case, my
they
lord,
have filed affidavit, now new council has come. He is saying, I need to verify. What is going on, my lord? Once affidavit was filed, a matter ends. What is the scope for them to file fresh affidavit?
my
Or is it to confirm?
Affidavit was filed by the government or no?
Yes, yes.
not it.
We are just performance.
They have filed the affidavit, my lord. Can we see?
My lord, that is, I understand, my lord. Thing is that, my lord, that document and that nothing under relevant records with me now, my lord. I have entered into appearance for the first time in this case, my lord. So that's why.
This is something, my lord, new trend, my lord, has come, my lord, after filing affidavit. And now they are saying, my lord, one more. Two, three, and
My lord,
6, they have filed the affidavit.
my lord, I beg to mention
6 to 9.
item number 21 and 22, my lord. Here also the collusive affidavit has been filed by the directorate level.
Don't say.
Directorate level, my lord.
Please, Mr. Counsel, don't say.
My lord, I'm not saying.
Roshi is not taking up these 2 items. Why do you say all this?
That is why, my lord, that is the officer who shown the affidavit without approval to the competent, because they have been placed under suspension and inquiry is going on. Now, similar, that's why I'm entering for the first time this case, my lord. The record is not with me, my lord. That's why, my lord, I just apprising the before the my lord. That
for last, my lord, 7 months matter has been listed, my lord. Now they are at the second. When we are, my lord, we have prepared the case and we are about to, my lord, argue the matter. Now they have come with a new plea.
it's not a record is not with me, my lord. Council changed, my lord. That's why, and we to take instruction to the competent court.
That cannot be a ground. Council change, council is to, my lord, succeed everything.
It is, my lord, any case, my lord, record is without my lord, without proper instruction, my lord, it's not possible. That's why, my lord, it's maybe.
That change the proper instruction by the time. Out of my, my lord, 40 years of practice, I have never seen, my lord, once affidavit is filed.
No. That is why, my lord.
Now, question is that most probably he is not denying to the affidavit. He wants some more time.
Yes, my lord. I need to obtain that record, my
But
lord.
as per your instruction, whether the affidavit was.
But even I don't know, my lord. I've talked to the government level, commissioner level. They cannot say because their record is also not with them. That's why, my. So I need to. But without hearing my argument, how that the proper hearing can be done, my lord. That's not possible, my lord. That's why.
The commissioner himself filed the affidavit, my lord.
No, whether.
Kindly see, the commissioner is respondent number 2.
No, whether is this
filed by, my lord, respondent number 2.
Whether it's filed by the commissioner or not, that it only can be verified, my lord.
New commissioner, I'm going to assume the charge, and he is, my lord, creating all problems in earlier item also, in this item also. Whereas commissioner was duly represented, and affidavit was filed on behalf of earlier commissioner. What is the scope for the present commissioner to, my lord, setback?
My lord.
Respondent 2 is the commissioner. And affidavit was filed on
Simply,
behalf of
simply showing in the affidavit that the name, the number of the respondent, that will not suffice, my lord. Thing is that whether that person who showed the affidavit, whether this was duly authorized by the authority or not. But as per my lord, the director is not a government, but he cannot represent the government.
My lord,
it's the undersecretary.
As per their submission, the affidavit was filed by the respondent number 2, that is the commissioner.
My lord.
Maybe okay then.
Okay, my lord. That's it. But that is not with me. Everything, my lord. The entire document is not with me.
My lord, Postmaster General of Supreme Court, my lord, and our High Court also. Once affidavit is filed, that should be deemed to be an evidence. Question does not address to the, my lord, affidavit.
One thing, most probably he may not be able. I don't know.
My lord, I am
as
no
per your submission,
we are ready to accommodate him, my lord, but not in that way.
As per your submission, the commissioner or the respondent number 2 has filed the
affidavit. Yes, my lord, also kindly.
So that may not be, or he may need some more instructions in that way.
Yes, I have nothing to say.
Then,
not in that way. Why should he blame every time, my lord, collusive affidavit, collusive affidavit? Can you prove it? He is making the statement from bar, my lord, as a responsible officer of the court. And he is getting, my lord, he intend to get us, my lord, involved in the, my lord, collusion. Somebody has filed affidavit in your favor means that we are also equally involved.
Okay. Heard Mr. Pukasti, the learned counsel for the petition, and also heard your Mr. No?
T Tagum, my lord, Tabat Tagum,
T
Tagum.
Tagum, the learned
Standing Council.
Standing Council, Government of Arunachal Pradesh. Full stop. And also heard your Mr. Y. Iram, for Standing Council for Education Department.
No, no, it's from the
Huh?
finance man,
1, 4, and 5.
chief secretary.
1, 4, and 5. And you are representing the other.
My lord, yes. Even I don't have that
Representing the,
file with that. Education.
You also government. Government advocate. You know, the learned government advocate appearing on behalf of respondent number 1, 4, and 5. Post. It is submitted by Mr. Pukasti, the learned senior counsel, that the respondent number 2 has already filed their affidavit.
Respondent number 2, along with my lordship, can you see respondent 2, 3, 6 to 9.
Respondent number 2, 3, 6 to 9 has already filed their affidavit. And thus, there is nothing to argue in this matter, and they have already admitted the as to an affidavit, they have already admitted file an affidavit, and accordingly there is nothing to argue in this case. Post. In this context, Mr. So and so, the learned counsel appearing on behalf of
Education Department.
Education
Department.
Learned counsel appearing on behalf of the Education Department has submitted that the file the earlier the case was conducted by Mr. T. Jamu, but he has been newly engaged from the department, and hence he do not have any instructions from the government, nor he has the relevant documents etc. in his position to argue the matter, and accordingly sought for some more time. And for first of and further, he submitted that he is not aware about the affidavit filed by respondent as submitted by the and accordingly it is submitted that some more time may be required to get some instruction from the department.
Can you make an observation that affidavit which was filed by the respondent authorities are a part of it? He could have
already part of the record.
Part of the record.
Submitted that affidavit has been filed by so and so, and it is already part of the record.
Yes.
We'll mention all this.
And we have filed our reply. Against that affidavit.
Considering the submission made by the learned counsel for the respondent / the Education Department, Standing Council of the Education Department, I find it proper to give some more time to prepare the matter. Accordingly, matter be adjourned. As per your convenience, I'm.
15th of March. Because other cases are fixed on 15th of March.
15th of March. Please the matter accordingly. Oh, other two matters also you are there.
Oh, yes.
My lord, may direct the registry to reflect my name.
Yes, sir. The registry is accordingly directed to reflect the name of so and so in the court list from the next date of list.
And my case may also be melody.
Yes, yes, your name is also not there. Twitter name, correct?
Deeply of it.
Obliged to you. Obliged.
Do we have exactly this? Oh, I thought that more matters are there. That's why. Today you are here or?
No, I'll go back.
You'll go back.
Stay back here, I think.
Yes, next week also I'm having my bench, so that's why I'm here.
Obliged.